Hello, everyone. My name is Maxim. I'm a legal operations specialist here at Howley, and today we're going into the basics of United States pre-litigation tools, and we'll be using as examples cease and desist and demand letters. Compare them and understand what are these documents and what are they used for. Let's start. First of all, let's answer the question, what is a cease and desist letter? A cease and desist letter is a formal demand sent to an individual or organization to immediately stop a specific activity that the sender considers unlawful or infringing. Uh, while it has no inherent legal force, it often serves as a first step before litigation and may be used as evidence in court to show that the recipient was warned. Generally, these letters are used in legal relationships that are somehow connected to copyright infringement, debt collection, trademark infringement, defamation, harassment or stalking, breach of contract, unfair competition, use of trade secrets, and other legal relationships. What is important to understand that these letters are not court orders and do not require immediate legal compliance. However, ignoring the letter may lead to litigation. A respectful response or negotiation may prevent costly lawsuits. In some cases, e.g., debt collection, failure to comply after receiving the letter may be a statutory violation. For debt collection issues, consumers send cease and desist letters to debt collectors to demand cessation of harassing or repeated communication with them. For copyright infringement issues, copyright holders use cease and desist letters to demand that someone should stop using their or reproducing their copyrighted work without their permission. Generally, such a letter contains a description of a copyrighted work, evidence of the unauthorized use, and a demand to remove or stop infringing use, and also a deadline by which such actions are to be performed. For trademark infringement letters, they generally include the trademark description that's being infringed, how the use is confusingly similar or dilutes the brand, and a demand to seize and potentially destroy infringing materials. For general legal violations, such as described in here, the defamation, harassment, or stalking, breach of contract, and so on and so forth, the letter may reference common law rights, state statutes, or a contractual provisions. On a federal level, different cease and desist letters are regulated by different mainly used legal acts. What is important to mention is that all types of cease and desist letters generally are subject to federal regulations only and do not have specific legal regulations on the state of legal regulation, on the level of state legal regulations, I'm sorry. So for copyright issues, the main legal act is the Copyright Act of 1976, also as it's known as the Title 17 of the United States Code, specifically 17 USC paragraphs 106, 501, 502, and 504. For issues with trademark infringements, the main act is the Lanham Act, which is also known as the Section 15 of the United States Code, and also they described in here articles of such an act and its paragraphs. For debt collection matters, Fair Debt Collection Act or FDCPA is used, and also it is common to use Section 15 of the United States Code, specifically paragraph 1692. And regarding general matters, there is no direct legal regulation. The form is arbitrary, but it can be evidence in court provided that the parties are identified and the date and fact of the notification is known to them. Regarding in-state legal regulations, many US states have independent laws that govern specific legal relationships that we've mentioned before, like debt collection behavior, consumer protection and unfair practices, trademarks at the state level, defamation and harassment laws, and so on and so forth. Still, generally, state-specific regulations may widen rights and responsibilities of the parties, but do not directly imply on contents or form of cease and desist letters of any kind. Also, under general practice, there exists a legal instrument called cease and desist order. It is common for people to misunderstand the legal nature and purpose of cease and desist orders, and therefore they think that cease and desist orders and cease and desist letters are the same. Still, they aren't. A cease and desist order is a legally binding directive issued by a court of or regulatory authority. There are many authorities that issue them, requiring the recipient to stop unlawful activity. By contrast, a cease and desist letter is a private party's warning, not automatically enforceable, but often effective in practice. Here on the slide, you can see the example of cease and desist order for a private party from the City Commission of the City of Lawrence in the United States. Next, we have a demand letter. A demand letter is a formal written communication used to assert a legal or financial claim. It is typically sent by one party of the relationships, the claimant, to another party of the same legal relationships, the recipient or the other, requesting the fulfillment of specific obligations such as payment of a debt, performance of a contract, or cessation of harmful behavior. This document is often the first step before filing a lawsuit and serves as a notice that the sender is prepared to take legal action if the matter is not resolved. In practice, it is used as a legal instrument that has a few specific functions. Firstly, it resolves disputes in a court. Demand letter can prompt compliance and avoid expensive litigation. I think that is understandable. Secondly, it establishes evidence. If it documents the claimant's attempt to resolve the issue amicably, which courts often view favorably. The third is that it clarifies positions for the parties and of the parties. It clearly states the facts, claims, and remedies sought. It triggers the deadlines. I think that's the most important function of this document. In many cases, it activates legal timelines, e.g. 30-day response periods. These timelines are legally binding. They are often prescribed in legislation, and or in the provisions of specific contract that is the basis for on foregoing demand. Therefore, we need to also understand what do we need for a demand letter to be valid. You can see a lot of text in here, but still it is logically understandable. For example, requirements for a demand letter mainly consists of the clear and precise description of the issue, amount, or action that is demanded. Secondly, a factual support throughout relevant documents and timelines. And thirdly, professional tone, free from threats, exaggerations, or false statements. For the recipient, information that is being provided to them through a demand letter has to be clear and specific. The demand letter has to give the recipient an opportunity to request additional documentation, clarifications, or settlement proposals. And also, it should focus on inclusion of legal rights notifications where required. It is required by jurisdiction, e.g., assistance notices, deadline extensions. So that generally, demand letter should include such an information. First of all, the identification of the parties. Secondly, the statement of facts. Thirdly, nature of the claim. Fourthly, the specific demand. On the fifth place, we have evidence that is being provided with the letter. Six is the deadline for the response on this letter. And the seventh is notice of the next steps. Here on this slide, you can see 4 demand letters that are widely used throughout the United States. And these demand letters demonstrate the types of the demand letters that are the most popular throughout the United States legal practicing. First is the payment demand letter. It is sent to request unpaid invoices, loans, or fees. The second is the breach of the contract demand letter, used when one party fails to meet agreed terms in the contract. The third is the personal injury demand letter. And the last one, the fourth, is the tenant-landlord demand letter, which is, in this case, a security deposit demand letter. There is really a group of demand letters that exist in tenant-landlord legal relationships. And for an example, you can see one of them in here. At federal level, general regulations regarding demand letters are consisted in Fair Debt Collections Act, FDCPA, Fair Credit Reporting Act, FCRA, and Telemarketing and Consumer Fraud and Abuse Prevention Act. These acts outline main requirements for the information that has to be present in demand letters, and in fact give a right to send such a demand letters for the parties interested. Regarding in-state legal regulations, I will use as examples only these 3 states that you can see on this slide, but I highly recommend you to read and make yourself familiar with the Notion article regarding demand letters that is present in our Notion database. So there you can see almost all the variations of legal regulations throughout the United States on the level of in-state legislation. First question that is to be regulated by in-state legislation is often the response time requirements. Some states mandate a minimum number of days to respond. For example, it's 30 days for patent-related demands and beyond. The second is that in-state legislation may require disclosures in cease and desist letter. States may require specific language in consumer or debt collection demand letters, e.g. it's California's Rosenthal Fair Debt Collection Act. Good faith requirements are also common. Demand letters must be made in good faith and must not include threats or false information. I think that's understandable. Delivery method regulations also exist. Some contexts and jurisdictions require certified mail, personal service, or electronic delivery with read receipts. E.g., it's West Virginia Code for lien claims. And also there may exist industry-specific rules for such documents. Demands related to real estate, employment, or intellectual property often follow specific rules. And for example, it's a home improvement refund demands. that is regulated by Wisconsin Administrative Code. As you can see, the administrative legislation may regulate such matters. Regarding comparing these two documents, cease and desist and demand letters, we need to focus on, firstly, on the purpose on which these documents are being crafted and sent and used. First of all, cease and desist letter is used to stop illegal or harmful behavior, and demand letter, on the other hand, to request payment or action. Therefore, cease and desist letter focuses on the conduct of person, private party or a company, it really doesn't matter. And demand letter focuses on compensation or legal remedy. Why is it so? Because when we send a cease and desist letter, we consider that someone's behavior is illegal or misleading. But when we send a demand letter, we demand a compensation on the basis of contractual agreement or legal provision. Legal grounds are therefore often tort or IP law, and for demand letter, it's often contract or tort law. In case of urgency, it's immediate halt for cease and desist letters, but for demand letters, legally, there exists remedy within a deadline for answering it. And regarding the tone of a letter, it's warning and cautionary for cease and desist letter. For demand letter, it's more assertive and remedial. I'd like to also pinpoint the influence on the legal practice that is caused by these documents in the United States legal practicing. So the first function that these documents fulfill is pre-litigation dispute resolution. I think that's understandable. The second is legal notice and preservation of rights. These documents are really good instruments for preserving one's rights and following a good faith recommendation throughout legislation. The third is strategic leverage. They create strategic pressure on the recipient to comply or negotiate by articulating legal positions and consequences. They frame the legal narrative and influence potential settlement terms or litigation posture. They are documentation of good faith efforts. That's also understandable. They are instruments for compliance and risk management. And also they fulfill the function of gatekeeping and filtering, which means that these letters often filter out non-meritorious claims or misunderstandings before they reach litigation. Also, I'd like to point on the questions that may arise from our customers regarding these documents. And first of all, of course, people ask if the cease letter or demand letter templates legally enforceable. These letters, it doesn't matter if they are templates or they are written by one himself or herself, are not legally binding, but serve as formalities that can support later legal action. Is it mandatory to send a demand or a cease and desist letter before filing a lawsuit? In many cases, no, but we've discussed cases where, yes, it may be mandatory. Can using a template affect the legal validity of my claim? No, as long as this letter is accurate and properly tailored to the facts and applicable law, it won't be a matter of any problem. Do I need to cite laws or statutes in this letter? That's not mandatory, but it's still a good practice to do. How do courts view these letters during litigation? We've discussed this question about as a evidence of notice, good faith, and attempt at pre-litigation resolution. Can I use the template without legal advice? Yes, but legal advice may be advisable. Will sending such a letter expose me to counterclaims? If the letter is okay, nothing will be bad. If you're doing it in accordance and in the regards of the law or contextual provisions. Should I include a deadline in the letter?